Morning, everybody. Welcome to March's coffee break employment and HR briefing. It is the 4th of March, and today we are going to be talking about redundancies. I've had quite a bit of interest in this one, hopefully because you're not all considering redundancy situations, but I suspect because it is one of those areas where I know there can be some confusion, I know there can be some areas of dispute, so that's why I wanted to talk about it. As always, these sessions are being recorded. This one and all previous ones are circulated to everybody who signs up. They're also publicly available on the Fretton's YouTube page. So if there's anything that you've missed in the past or anything that you think a colleague might be interested in, please do point them in that direction. I've also got access to the chat and Q&A as always. I'll try and address issues as they come up, any questions that people might have as we go. If not, as I've always done in the past, I'll pause towards the end and take any questions at that point. Purpose of today, as with all previous sessions, is really just to give an overview. This isn't intended as specific legal advice on how to run your personal redundancy situation, but the idea behind today will be to highlight issues, to identify potential red flags and areas where you might want to be particularly cautious if you are going through a redundancy exercise. So, quick overview of today's session, then we'll talk about the actual circumstances that give rise to a redundancy and the various forms of redundancy that exist in law. But the main focus will really be on the consultation process, avoiding compulsory redundancies as a mean of dismissal, and in particular, collective consultation rules. Unlike the last few sessions that we've done, there won't be a huge amount of focus on any changes coming under the Employment Rights Act. There are a couple of significant points that will matter, but redundancy law is, for the most part, not drastically changing in terms of how we do it in practice, I suppose. But there are things to be aware of, there are things to be conscious of, and I think redundancy, as I alluded to at the start, is one of those areas where mistakes can happen because I think there's a lot of grey areas despite how rigid the rules all look, especially when we're talking about collective consultation exercises. So, without further ado, we'll launch straight in. What is a redundancy? When do we have a redundancy situation? And how do we start approaching them? So, redundancy as a dismissal, first of all. Yes, the basic legal position is that redundancy is there in the Employment Rights Act as a potential form of fair dismissal. It sits alongside capability, conduct, some of a substantial reason. All of those are the ones that we look upon when we're trying to establish whether we can dismiss an employee. It is a form of dismissal because ultimately it's you as the employer making the decision to terminate employment. And so it is a dismissal in that sense, as opposed to any form of resignation. If you look at that legislation, the redundancy takes place in one of three situations where it is wholly or mainly because of one of these three things. And they are that as the employer, you cease to carry on the business that the employee is employed to do, that you cease to carry on the business in the location where that employee is employed to do that work, or the requirement for work carried out by an employee of that particular kind, that kind of work, diminishes substantially either across the business or within a particular location. We will break down the three of those. Because redundancy is a potentially fair reason, it's also a potentially unfair reason and can be challenged in exactly the same way as every other form of dismissal. Therefore, it must be both procedurally and factually fair, all of which we'll address later in the session. The procedural one, again, I think it's one of those areas where it's quite easy to get caught up on the idea that we've got this very, very rigid collective consultation process which we must follow. And I think sometimes the problem with these very rigid approaches that are set out in statute is we get caught up on those, miss something else, and then the process becomes unfair because we're so caught up on doing this right. Hopefully by the end of the session that will be less of an issue. So, my presentation doesn't like me very much today, does it? First one, the employer ceases to carry on the business at all. And this is the total business closure scenario, or in some situations, it'd be a closure in elements of the business, particularly where there's group companies. This will primarily be insolvency situations, and if this one arises for you, you will almost certainly have an insolvency practitioner of some kind involved giving advice, alongside probably accountants, corporate lawyers, and potentially also employment or HR. Employees' rights can be affected in an insolvency situation, so it's important to be aware of those. It's outside the scope of today's session because it can be quite complicated. But ultimately, for a redundancy situation here, what we're looking for is the business is closed, therefore logically there is no more need for the employees. It's particularly important that any official process, particularly in relation to the insolvency service, is carried out correctly here, because the government and the redundancy payment service must be aware that this situation is likely to arise if that is potentially going to be a situation. There is a slight quirk here where if there is a business wind down, particularly a compulsory liquidation insolvency situation, there may also be an associated buyout. If there is an asset purchase to which TUPE is applicable in this situation, it is not a redundancy situation, it is a TUPE situation. The important thing to remember there, and we will come back to it, is the consultation duty exists both stages, both ways, regardless of the process. There's a duty to consult if it's redundancy and the business is closing down entirely. There is also a duty to consult and inform properly in accordance with your TUPE obligations. So do be mindful of that. Obviously, as the outgoing business here, you may be slightly less concerned on the basis that you're the one winding down, but that obligation does still exist. The claim does, in theory, still exist as well. Failing to go through this process is likely to slow down any transaction, and in an urgent liquidation sale, or indeed in any asset purchase as a result, you may not want unnecessary delay caused by the fact that you've got to go through a consultation exercise first. That said, these situations becoming a problem are, of course, rare. If a business is liquidating completely, it's very unusual that there is scope for the employees to be able to do much afterwards in a purely practical sense, other than take their redundancy pay if they can afford it, go through the redundancy protection service if the business can't afford it, and ultimately move on. The business ceases at the employee's particular location, so this is more the specific workplace at which the employee is employed closes down, or the work for which they're employed to do no longer is undertaken at that particular site or location. Again, two fairly specific circumstances that are somewhat connected to, I suppose, potential liquidation exercise, but it is a winding down, a condensing of the business overall. I think the important thing to remember if you are talking about the closure of a particular sales site, a particular warehouse, a particular office location, is that there may still be an ongoing need for the job to be done in some sense. Just because you close office location A doesn't mean there's a reduced need across the business overall for that work, and the employee may well be prepared to relocate, to take up alternative opportunities. That is a way to avoid the compulsory redundancy that would come as a result, and so it should be considered and be discussed as part of the consultation exercise. This is also often the one in talking about location where we get offshoring, which does also potentially create a redundancy situation. There's an argument around redundancy stroke TUPE in that example, of course. Is the work being outsourced for TUPE purposes, or is there a redundancy because it's being fully offshored? Arguments do crop up in both directions. I would suggest generally it is safer to take the view that it's not going to be feasible for the employee to up sticks from Southampton, Bournemouth, London, whatever the case may be, and move to the other side of the world to start doing their job. It's much more likely to be viewed as a redundancy situation because the work is no longer needed where they are currently doing it. First one, final one even, diminished need for work of a particular kind. This is the most common one. This is the one most of us will have dealt with historically. It's also, I think, the one where there is most cause for disputes. If the business shuts down, it shuts down. There's not really much scope to argue that it didn't need to shut down or wasn't supposed to shut down. This one, however, does give rise to more areas of argument. Diminished need for work of a particular kind, i.e. work that is being undertaken by an employee or group of employees. It's the classic reduction from we need 10 members of sales staff down to 8. So important things to remember when we're talking about diminished need for work of a particular kind. it relates very, very clearly to the work. Now, this is particularly important to remember if you are advising a company or you are a company which is taking guidance or instructions from particularly a US parent entity. There are many case examples I could give you where US parent companies take the view that we want to make individuals A, B, and C redundant and try to structure the entire process around that. That will be an unfair dismissal in UK law because it's not a redundancy. You've selected the individual that you want to get rid of. You haven't created the business case for the work of a particular kind which has diminished. So that's always got to be the starting point here. What is the work being undertaken that has reduced before we start talking about who we then look at? The need for the work will inevitably continue in some sense because this isn't like the previous two examples of potential redundancies. It's not that the work has stopped being done. It's not that we're not doing the kind of work that we do anymore. There is simply a reduced need for the number of secretaries, the number of salespeople, the number of people in the finance team, because objectively there's been a reduction in our client base, in the external need, in the kind of work that we produce going on to a third party, all of those sorts of things. So there will be some kind of work continuing, which makes that not an argument. The fact that a job role of some kind still exists doesn't automatically prevent it from being a redundancy. There is just a reduced need. The bottom line, we need fewer employees to do the work for whatever reason. That's very likely to result in a redundancy situation. I've had a question just going back to, I think, to the previous point, what would be deemed acceptable for location move before redundancy is applied? I think it depends. There's a couple of ways that you can look at this. It'll crop back up later when I talk about suitable alternative vacancies more than anything else. But how this ultimately works is in two ways. You've probably got some kind of relocation clause in your contract anyway that will simply say a reasonable distance. UK law, as you've probably heard me say multiple times, is propped up by the word reasonable. And what it will come down to is what's reasonable for both the employer and the employee. If somebody suddenly has to increase their commute from 30 minutes to 2 hours, I think that's unlikely to be deemed reasonable. But the employee may be willing to do that. You know, I don't know, without wanting to typecast, but I can use myself as an example, if they are a single individual who doesn't have any sort of external commitment, wants to keep their job and enjoys their job, and they are quite happy to do that long distance commute more routinely, that is potentially reasonable for them. It keeps them in the same job, it avoids the compulsory redundancy. Hopefully that answers the question. So I've talked so far and I've used the phrase a redundancy situation. That term doesn't actually exist in statute anywhere. It's a dismissal by reason of redundancy, of which the three examples we've just gone through are the three things that amount to a redundancy. That said, we always use the phrase, we all know what it means, but it is important to always refer back to those various statutory definitions and the legal tests. It is sometimes easy to get caught up in this idea of we're in a redundancy situation sort of just because we say so. It is quite important to make sure that your situation is actually a redundancy and it's not something else that needs to be addressed in a different way. It's still got to be that you've established one of those three things does exist. That said, a dismissal for another reason can still occur in the middle of a redundancy process. There's absolutely no reason why not. If you are going through a redundancy procedure, you're in a consultation exercise, and a member of affected staff commits an act of gross misconduct, you are perfectly entitled to simultaneously be addressing that potential act of gross misconduct. Their dismissal then becomes for gross misconduct rather than the redundancy. What the tribunal don't like, for fairly obvious reasons, is trying to find something else as an excuse to get rid of somebody while you're in the middle of a redundancy exercise because it's potentially cheaper. So they don't like gross misconduct situations where ordinarily maybe you wouldn't have gone down a gross misconduct route, or where they are contrived to avoid a potentially expensive redundancy. Exactly the same reason that they don't like contrived dismissals in other situations as well. Equally, of course, and I'll come back to potentially unfair dismissals, the reverse is true there as well. We know it happens, everybody knows it happens. You've got a complicated grievance, disciplinary, counter grievance, or a capability procedure that might have an associated disability behind it, and suddenly it's discovered that there's a redundancy route as an option. Again, the tribunal are quite happy to look behind that, as I'll come back to. If the dismissal is not genuinely a redundancy, they will not be thrilled if you've gone down redundancy as your set reason. All three of those definitions of a redundancy situation refer to a business, and what we mean there ultimately is any trade or service provided in a commercial sense. I've said there it doesn't have to be a commercial or corporate entity, so we're not just talking about limited companies, LLPs, PLCs. I think it is safe to say that if you are providing a service, doing a trade, manufacturing something, any sort of commercial operation, and you have employees, you are probably a business. There are not very many people excluded from that, and where people are excluded from it, it's usually because by law they are not employees. So the armed services being probably one of the best examples there. Turning back then to redundancies as unfair dismissals. So yes, of course, where they're potentially fair, they are also potentially unfair, and they are potentially unfair in exactly the same way that any other form of dismissal can be unfair. Either they are factually so, in that there was no genuine redundancy arising, or the process followed was unfair, either because you didn't consult, which we'll come back to, or because there was a fundamental flaw in the consultation process itself. On the genuine redundancy situation, what I will say there is this is something which should have been established quite early on, and tribunals are, to put this as diplomatically as I can, often reluctant to challenge the genuine commercial view of a business. If your business case is relatively sound, if it is clearly established, and providing it doesn't look as though it is a contrived effort to get rid of people in a certain way just to make your life easier, it is not the role of the tribunal to challenge your commercial decision. If there is, on the face of it, a reduced need, and on the face of it there is a reduced need for work within ABC sector of the business, that does appear to be a redundancy within the diminished need for work of a certain kind category. It's unusual for that to be challenged successfully, but it doesn't mean that your business case doesn't need to be sound in the first instance. Okay, so do go through that process, do make that effort, do make it clear that there is a need for the redundancies, because that will simply mean it's very, very unlikely to be challenged purely on the basis that it's quite hard to do so. A business has to be able to make its own commercial decisions. In terms of process, we'll come back to that. It's almost exclusively around the consultation process, which will form most of the second half of the session. But areas to be mindful of: who is selecting, who is applying any final selection criteria, who is making decisions. Don't forget that on the back of that, it is theoretically and certainly practically possible for there to also be discriminatory decisions that are made. So if we think back to last month's session, which looked at discrimination generally, obviously need to make sure that we're not accidentally discriminating in our selection criteria. And if you go back to one of the sessions from last year where I talked about the use of AI in selection models, again, don't forget that any decision which has a legal effect on an individual, they are entitled to a human review of it. I mentioned section 98 there. That is ultimately the reasonableness test, which applies, as I'm almost bored of saying, to almost every test that we undertake in employment legislation and UK law generally. Any dismissal really boils down to, was it, in the circumstances, reasonable for the employer to treat redundancy as the reason to dismiss this employee in these circumstances? If you can tick all of those boxes, you've probably got a fair dismissal. I mentioned TUPE earlier in the context of a business wind down. Don't forget it also applies to a sale in a non-liquidation situation. It also applies to service provision changes. So if you are outsourcing your office cleaning, for example, that's a service provision change for which TUPE is likely to apply. If a redundancy is made primarily because of the transfer, that could be automatically unfair. Okay, so that arises in two situations really. One, the buyer asks you to make some staff redundant because they don't want them on board. That's a potential automatic unfair dismissal. The reason is the transfer. Or you are the incoming employer and you make a series of redundancies simply because by taking these people on, it's become too difficult for you to manage the business. You took on the business as it stood. You're not supposed to make redundancies having immediately bought it. That would apply equally to any redundancies that were made within your own business because you brought people in through a 2P transaction who are potentially cheaper. That would still arguably be because of the transfer. So again, there is scope for a potential automatic unfair dismissal there. When we're talking about unfair dismissals, one of the few times I'll mention the Employment Rights Act 25 in detail this year in relation to redundancies. Don't forget that will be a 6-month minimum service requirement as of the start of next year. And don't also forget they are removing the cap on unfair dismissal claims. That's not to say that punitive damages will necessarily start to be introduced in the same way that we see them in discrimination claims, but it does mean that for higher value unfair dismissals, there is more risk associated with them being pursued. I mentioned at the bottom there that consultation failure is relevant. Yes, in all redundancies, any failure to consult is likely to be a relevant factor. The staff affected should have an opportunity to understand the reason they're potentially being dismissed, and also, of course, engage in a two-way discussion about how that potentially could be avoided. In relation to collective consultation, it is also a distinct claim, and that distinct claim, as I'll come on to, does have punitive damages associated with it. Which brings me on neatly to consultation process and procedure. I haven't had any questions since the one earlier, so I'm going to assume that everybody's happy with what I've said so far, and I'll move on to consultation, both individual and collective in nature. So, first thing to remember with consultation is there's always a general expectation to discuss and consult. So even if you're making one person redundant, even if you have a pool of one, even if it's almost obvious from the outset that that individual is likely to be made redundant, don't approach it with the view that they are definitely going to be made redundant. It's ultimately a predetermined decision. So the expectation is that the individual will understand that the redundancy is likely to take place, and there may well be ways that it should be avoided. I've just had a question pop up asking even if voluntary. If we're talking about voluntary redundancies in the strictest sense, the redundancy process should have started first. And I'll come on to why that's important, particularly in relation to collective consultations in a moment. But yes, in the sense that you should have had a conversation about the potential redundancy before offering voluntaries, because otherwise it's not necessarily a voluntary redundancy, it's more akin to a settled exit under a Section 111A discussion. So there's always that expectation, because ultimately if you're dismissing an employee, they need to understand why, and they need to have that opportunity to talk about how it can potentially be avoided. Collective redundancies, there is an absolute legal obligation to consult, which is very difficult to avoid the moment you hit the triggers, which we will come on to in a moment. So in individual or small scale redundancies, yes, consult individually before finalising any decision. It's likely to be unfair if you don't. It's absolutely akin to going through a disciplinary process without having the investigation or the hearing or talking to the employee in any way whatsoever. We wouldn't dream of doing that, so in theory we should be doing the same thing in an individual or small scale redundancy. That said, unlike the collective consultation procedure, there's no specific rules in a small scale redundancy about how long that process should last or what it should look like. As a general rule, what I would suggest is that it should start with obviously the announcement, and then realistically a couple of meetings following that. You want a meeting where you can sit down and explain the situation to the employee, how it's likely to affect them and what you're thinking. You then want an opportunity for them to go away, consider that, consider their options, and have a discussion with you in light of what they now know, after which a decision can potentially be made. It shouldn't be a rushed process, but equally it doesn't need to take several weeks in the same way that a collective or any other form of dismissal would likely take. That process with an individual or with a small group of individuals will cover the reason for redundancy, ways of avoiding the dismissal, which may include alternative job roles within the organisation itself, or alternative structures. issues with the process that they might have. It is quite important to make sure that they don't object to the person making the decision, for example. Opportunities for alternative employment, that's both within the organisation and potentially outside of it, and any support that you might be prepared to offer in finding new work, whether that's an outplacement service or time off for interviews and seeking alternative employment. Right, collective consultation, the big one. This is basically the definition of when you trigger a collective consultation. It is 20 or more redundancies which are proposed. And before I go any further, that word proposed is very important here. There's been a recent EAT test case confirming what we already suspected, that this is a forward-looking test that should be applied by the tribunal. What they will do if a failure to collectively consult is challenged is they will look at the employer, they will look backwards, and they will look at the point at which it seems likely to the employer that 20 or more redundancies were likely to take place in a way that met the rest of this test. So, for example, if you have been sat in a board meeting a year ago saying, we think we're going to need to make 40 redundancies next year around Easter, that is the point where you have proposed 20 or more redundancies that otherwise meet this test. So, yes, people stagger, of course they do. Yes, you can stagger. But it's important that the reason that you're staggering is a genuine business need, i.e. what we'll do is we will get rid of the people who are manufacturing our product first, because the need for that will cease. Then we'll get rid of the people who deal with the after sales side of that, because there'll be a little bit of time where they're still needed. And then finally, we'll get rid of people in the finance team once all the bills have been settled and everything's been sorted out. That is 3 genuine reasons to potentially have 3 different sets of redundancies that are taking place at different times. What you want to avoid doing is going, we need to make 40 redundancies, so we will just do them as 8, 6, 9, 7, 5, 8, blah, 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 blah. Because to an employment tribunal, that is going to look as though you are actively trying to avoid the rest of this test. Okay, so it is important to remember a tribunal will look backwards, they will look at what you were thinking at the time, and if they think you are actively trying to avoid your collective consultation duty, they will not be happy with you. So those 20 or more proposed redundancies, they include voluntary redundancies. And the reason for that is that the dismissal is basically still for reason of redundancy. And this is important. If you look at the test around this, it uses the phrase redundancy related dismissals, not actual redundancies. It includes anybody who is redeployed or moved to an alternative role, because again, if they weren't redeployed or moved, there would have been a redundancy dismissal. You include those with under 2 years service if the reason you are terminating their employment is because of the redundancy situation. In that situation, you'll probably get away, of course, 2 years at the moment, 6 months next year, you'll probably get away with a genuine failure to pass probation and all of those sorts of reasons. But if it can be established that the real reason was that there was a redundancy exercise in the background and they were, in a sense, included in it, they are included in that number. You include fixed-term contracts which are ended prematurely due to the redundancy, because again, that is a redundancy-related dismissal. So it's quite a comprehensive group, and it is deliberately designed to include as many people as possible so that collective is more likely to be triggered. It is 20 or more proposed redundancies at a single establishment. There was a lot of talk about the Employment Rights Bill changing that establishment test. It has not done so yet. And so an establishment still remains the somewhat vague test that we had before. The starting point is a single location, and that can be an establishment. However, part of the test is all around the degree of control and autonomy that that individual location has. So if you run out of 3, 4, 5, 6 locations, and there are redundancies taking place at each of them, and it is clearly connected and related and being driven by centralised HR, centralised finance team, centralised board of directors, there is an increased chance that your various locations are actually going to be considered a single establishment. So the best example of this, actually, if you've got staff who exclusively work from home, and I'm only going to throw this out there as an idea, what is the establishment? is that a single redundancy dismissal at each of their respective homes, or is it collectively that their 50 or 60 homes should be considered the establishment overall? I think a tribunal, or indeed a higher court, is going to be open to the idea that their work location is less important than how they are treated within the business. So if they all fall under the same management structure, the same HR, the same finance team, all of those sorts of things, I think they're more likely to be deemed a single establishment. So 20 or more redundancies, including that lot, at a single establishment, whatever that may be, within a rolling 90-day period. That is the time between the first and last dismissal, and it is any given first and last dismissal by reason of redundancy. So a couple of more questions which have popped up as a result of that one, and I can understand them. 20 or more redundancies proposed in the same role, department, or across the whole business. It is that test. It's 20 or more redundancies of any kind for whatever reason at an establishment within a rolling 90-day period. So it's not necessarily across the whole business, unless your whole business is, in your situation, potentially the single establishment. Job role is completely irrelevant to this test, unless you can demonstrate that there is a clear distinction between the roles, and therefore that gets you out of the 90-day period. Question about suitable vacancies in nearby locations. We will come back to suitable alternative vacancies at the end of the session, so thank you for preempting the question. Okay, things that are likely to be of significance to you when you hit that collective consultation duty. First thing to remember, I'll start with the one that's got a criminal offence attached to it. As soon as you're aware that this is likely to happen, you must think about notifying the Redundancy Payment Service. That is Form HR1, which can finally be done online. That must make its way to the Redundancy Payment Service at least 30 days before the first redundancy, if it's 20 to 99, or 45 days before if you're making 100 or more redundancies by reason, dismissals by reason of redundancy. As I say, it is an offence to fail to provide that information correctly. It's one of the few areas of employment law that we deal with more routinely that does actually have a criminal offence attached to it, so please do be very, very mindful of that. And of course, it goes without saying, you can't simply protect yourself from the potential criminal obligation by filling this form in and then not doing a collective consultation or vice versa. The fact you've done one strongly suggests that you should have done the other. The collective consultation period itself then mirrors those figures, and that is how long that collective consultation period must last. There cannot be an earlier dismissal by reason of redundancy without breaching the collective consultation rules. In practice, who do we consult with and what does collective consultation look like? Well, the point is this is one of the few pieces of legislation that did change in sort of the last 40 years that had anything to do with trade unions. So the first priority is to a recognised trade union representing part of the workforce which is potentially being made redundant. If there is a recognised trade union, then they are consulted with in respect of those employees. Not probably an issue for most people at the moment, but bear in mind, again, the Employment Rights Act, increased access arrangements, easier ways to get recognition, lower thresholds, all of that sort of stuff. It could start to crop up more in the future. If there's not a relevant and recognised trade union, the next step is to consult with any appropriate existing employee reps, if you have internal informal work councils and things like that. Failing both of those, you as the employer are under an obligation to offer and facilitate the election of representatives among the affected staff. That can be a nuisance, it can be quite involved, and more importantly, your collective consultation process cannot start until those reps have been appointed. So how this works in practice, you identify that you've got to go through a collective consultation process, you notify the staff of that, of their right to appoint reps, give them the opportunity to nominate either themselves or others. It is then on you as the employer to facilitate a free secret ballot for the appropriate number of representatives, and then to engage with those representatives once they've been elected. In terms of how many and how that actually works, it depends on the structure of your potential redundancy exercise. What you're looking for is appropriate representatives from each what for collective consultation is called a constituency, but in practice is basically your pool. It's the effective grouping of staff. You're probably going to need at least 2 reps from each group, if numbers allow, in order to effectively consult. If there is an absolute failure in all of the above, i.e. staff do not nominate anybody, or you go through an election process and nobody bothers to vote, you can then consult directly with the affected staff, even in a collective consultation situation. The information which has to be provided to them does, however, not change. So I think that probably indirectly answers the question that's just come through. If absolutely nobody wants to be a rep in that situation, you've provided the opportunity. They haven't exercised their right to appoint reps, so you go back to a default of consulting directly with the affected staff. Don't forget that in a collective consultation process, you will also consult individually to some extent anyway. That duty doesn't change. The staff may not want to talk to their rep about something that affects them personally, so you've still got to give them the opportunity to talk to you directly regardless. A couple of new rules just to be aware of. Again, one of the few things in relation to the Employment Rights Act, proposed changes next year. I talked about the threshold test a moment ago. So it may well be that at some point we see a change in the rules as to some kind of new trigger point for collective consultation if there's redundancies across a wider business. And for the very, very, very few of them who are likely to be on this call, there are talks about changes to additional protections for workers on ships which operate outside of Great Britain. Funnily enough, I've not read up on that one. If anybody would like me to and give you some more details on how that is likely to work, I suspect it's got something to do with P&O. Please do let me know. I'm happy to look into it if necessary. There's a question about staff association. Do you have to offer them the choice to choose their own reps too? You'll need to look at the rules on that, and I'd need to know exactly how the staff association actually works. But in terms of order of priority, union, if the staff association are themselves appropriate reps to consult with, so in the same way that a formal remuneration committee in relation to a pay change would be the appropriate people to consult with in a pay situation, it may well be that the staff association are by default themselves the reps. If they're not, then it's back to the entire affected cohort of staff under the redundancy having those rights to appoint reps sort of within that sphere. Can the rep consult on behalf of all staff, even if there are individuals who do not agree with the negotiation? If so, doesn't this cause issues? Yes, it's a really stupid situation. I think probably the next question is going to sort of implicitly start to answer that question in the next slide. So how an effective consultation works, this is the information that you have to give if a collective consultation triggers and if you have reps appointed. If you have reps appointed, they're entitled to this information. If reps are not appointed, you still have to give this information to the staff individually. So it's exactly the things you would expect. It's the reasons for the redundancy, the categories, the pools, the constituencies of people affected and how many there are in each group, how you're intending to select people, so that is implicitly a consultation on your selection criteria, how you'll carry out the redundancy, so again, that is then implicitly a consultation exercise around what that process will look like, what discussions there will be, who will be making decisions and how those decisions will be made, and ultimately a calculation of payments, even if it's just statutory entitlement. So the question about can the rep consult on behalf of staff, even if there are individuals who don't agree, yes. The collective consultation exercise is intended as a way to make sure that the staff are represented in the overall process and procedure, so it's all of these things, and any issues that might arise, but it is not the same as an individual staff member making representations about their own circumstances. So even where there's a good and effective consultation collectively like this, if you've got a staff member who says, fine, I'm happy, that information can pass back and forth in a general sense like this, but I've still got things employer that I personally want to raise with you, and I do not intend to go through the reps to do so, there is still that obligation to talk to that individual member of staff, and indeed every individual member of staff through the process anyway. So in practice, what a collective consultation looks like, the long-winded process of appointment of reps, Consultation then starts with those reps that's broadly on process, procedure and everything overall. And then you're likely to need to talk to individual members of staff anyway, simply because they've still got a right to know what's going on and consult with you, certainly if they've got a personal concern about process. So I think I've probably just answered that question, but in reverse. And as I was just alluding to there, the purpose of consultation, therefore, is twofold. It's to keep the staff informed of what's going on and their rights, but it's also opportunities for the staff reps and indeed individuals to come to you and explore options that may not result in a compulsory redundancy taking place. They may have ideas about restructure, different working hours, different working patterns that people are prepared to agree to, that you may not have considered, or that you had assumed staff would not be happy to engage in. What happens if we fail to consult? We've got a potential unfair dismissal claim, which, as I've said there, don't forget the cap is being lifted on that. It's not clear yet whether that's going to allow for sort of more punitive damages, hopefully not. The actual punitive one that exists in a collective consultation is the protective award. It is currently, for the next 3 weeks or so, up to 90 days pay per affected employee. That rises to 180 days from April. So a failure to collectively consult with a huge number of staff, there is a risk of it being up to 6 months pay per employee simply for not going through that collective consultation exercise properly. I deliberately say up to there because the maximum is not always awarded. So if you do get halfway through a process and suddenly realise that a collective consultation actually should have been triggered, you can mitigate the risk of that protective award by starting to consult and engage in some sense at that stage. It is always better to do something if you realise you probably should be than to do absolutely nothing. And that's broadly what a couple of the recent cases I mentioned earlier have just said. There is an exceptional special circumstances defence where a complete failure to consult can arise if there is absolutely no way that you could feasibly have done so. It's exceptionally rare, as I say. It's usually only in very unexpected insolvency situations. I wouldn't seek to rely on it. And the point still remains that you should take steps to do what you can, even in those situations. Again, it all boils down to, forgetting the law for a moment, HR good practice, communicate with the staff, keep them aware of what's going on. People who know and understand are less likely to cause an issue. Very quickly, we run through pooling, selection and some final bits and pieces. So pools I've alluded to all the way through. They're groups of similarly skilled employees. The next point cuts both ways. It's not simply their job title, but their job title can be a useful starting point. It's about overlapping skill sets. There's no absolute test as to where that Venn diagram is drawn as to whether you should be including people in a certain pool or not. You'll always have arguments both ways. I should be included with them, so there's less chance of me being included. I shouldn't be included with them at all. They're the ones who should be being made redundant. This is one of the most complicated points to get right if you're going through a particularly large scale redundancy. It's also a nuisance when you're at a very, very, very small scale and you've got only maybe 1, 2 or 3 people potentially involved, because there's no doubt going to be personal issues involved as well there. There may be existing agreements in the unusual circumstance that you're covered by a collective agreement about how redundancy pooling works. That takes priority. If not, as I've said in relation to a collective consultation exercise, the pool, the group, the selection criteria should all form part of that collective consultation process. I'm not going to spend a huge amount of time on selection criteria today. I've done it in a previous session, but remember that your selection criteria should, insofar as possible, be objective, fair, and outwardly measurable. The more subjective your selection criteria is, the greater risk there is that somebody will turn around and say, so-and-so's only scored me 2 because they don't like me. Criteria can be weighted, there's no issue with that at all, but remember, the more complex your weighting, the more complex the calculation system for that, the more scope there is for argument. That said, the job may require it. Selection process and selection criteria can be based on difficult to measure subjective soft skills, for example, but again, you need to make sure that you can show that it was at least objectively assessed and applied. You can be marked down for disciplinary and absence records, particularly where there are live warnings, but be mindful of discrimination. Any leave linked to a pregnancy, treatment or sickness absence due to disability, etc., all carries a risk of a discrimination claim. I have occasionally seen willingness for flexible working to be included on a selection criteria. Again, remember that carries a risk of both sex discrimination and potential disability discrimination as well. Very briefly, because I do want to allow time for questions at the end, let's talk about entitlements on redundancy, and this is where I'll cover suitable alternative vacancies. So just quickly, the financial entitlements for somebody who is made redundant. Notice period can either be worked, it is the notice to be given by the employer, you are the one terminating their employment, so it's either the contractual entitlement or 1 week per year of employment statutory, whichever is the greater. Remember that if you are going to make a payment in lieu of notice, there must be a contractual right to do so, otherwise you're in breach of contract. Redundancy pay can be statutory or contractual. Again, if it's contractual, bear in mind there is a small risk that HMRC will deem it a taxable payment, so do just be mindful of that. Statutory redundancy pay is always tax-free. It's within the Income Tax Earnings and Pensions Act threshold of 30,000. The maximum amount is below 30,000. Redundancy pay, use the online calculator to get this right. It's absolutely the easiest way to do it. Length of service, multiply for the individual's age, weekly pay subject to the cap, and bear in mind that weekly pay includes all of the things that it does for holiday pay purposes, so regular overtime bonuses, all of those sorts of things. As I alluded to earlier, if we're in an insolvency or liquidation situation and the business cannot afford to pay a redundancy because there is absolutely no cash to do so, you must be signposting employees towards the redundancy payment service. They can recover statutory entitlements that way, providing it can be proven that the business cannot afford to make those payments and has failed to do so. Suitable alternative vacancies. So a suitable alternative vacancy, I think, is sometimes slightly misunderstood. So the first thing to bear in mind is that if you identify a suitable alternative vacancy for a member of staff, it should be offered to them. And the reason for that is that you are avoiding the compulsory redundancy. There is an underlying implicit idea that you are expected to try and avoid making somebody unemployed. And it goes to the basic test of unfair dismissal, doesn't it? Is it reasonable in all the circumstances for you to treat this individual as dismissed by reason of redundancy? Well, no, it can't be if there's a job over here that they could do. So there is an obligation, you should offer it if it's a suitable alternative role. One of the few times where there is active positive discrimination, priority for a suitable alternative vacancy must be given to those on forms of parental leave or who are still within the protection period. Don't forget, for people who have just returned from maternity in particular, that time period has extended quite significantly after the birth. If there are multiple people who may be appropriate for a suitable alternative vacancy, you can go through a competitive interview process. I'll come on to what a suitable alternative vacancy is in a moment. It must start within 4 weeks of the redundancy, and there is a right to a 4-week trial period in this situation. So how a suitable alternative vacancy technically works, there's sort of two versions of it. You've got you as the employer saying, I believe this is a suitable alternative vacancy for you because it's basically your job, just it's over here. If the employee wants to give that a go, fine, they get a 4-week trial period. The redundancy has technically already been confirmed at this point. They are redundant, but this is a suitable alternative vacancy. We'll have the trial period. If the trial period works, you stay enrolled, there's no dismissal, there's no redundancy. If the trial period doesn't work, and either you're not happy with it or the employee themselves isn't happy with it, you default back to the redundancy that you've already technically established. Only where they unreasonably reject it from the outset, this is where the employer's version of suitable alternative vacancy kicks in. If you as an employer say this is a suitable alternative vacancy and they just say no, I don't want it, in that situation they may lose their entitlement to redundancy pay because they are unreasonably rejecting a suitable alternative vacancy. That is a redundancy, but it is without the redundancy pay. because in effect what they've said is, I don't want it, I'm leaving. It sits in a very legal grey area somewhere between a resignation and a dismissal by reason of redundancy. Suspect I'm going to have questions on this. So, can we offer a longer trial period if the employee asks? What would be the associated risks? Yes, technically you can. I would suggest that a review period takes place after the 4 weeks anyway. You will want to get this absolutely written and confirmed in writing. The biggest risk is that the longer that goes on, the more likely it is that they've just become established in a new job. So if it's not working at the end of that period, you may find it's more difficult to go less default because the statutory right is only 4 weeks. If there's only one applicant, do you have to interview? No, you don't. So that answers that question. Do you have to implement a 4-week trial period? Well, they've got the right to it. So the question would be, if you don't implement it, even with the employee's agreement, what happens if at the end of, say, 3 or 4 weeks, the employee decides that the role maybe isn't right for them for some reason? I think they would probably still have the right to say, I was entitled to a 4-week trial period, so I still want to default back to the redundancy, please. So what is a suitable alternative vacancy? I alluded to this earlier. There's a 2-part test. There's the objective job test. Is the pay, status, location, skills, terms and conditions all reasonably similar? It's quite a good way of identifying whether it's a suitable alternative role, in the sense that if you can marry their job description and terms across, it certainly looks like one. And there's also a subjective test, which pulls back to the question I answered earlier about what would reasonable relocation be, for example. Is it suitable for the employee in question? And this could be based on things like their home life, their medical needs, commuting distance. So it is a 2-part test. Does the job look basically the same? And does it work for this employee? I flagged it there twice because it's obviously important. The protected maternity period, they have priority. They must be offered a suitable alternative if one exists. That's not just an unfair dismissal. It is a specific discrimination claim if you fail to do so. People often talk about the percentage test. Yes, there is a percentage test, but it's often misunderstood from established case law. It works in one of 2 ways. The most common is the first one, because of course, if you as an employer have offered an alternative role, the employee refuses it, or you say has unreasonably refused it, they lose their statutory entitlement. That could be 12, 15, 18,000 pounds. The employee is likely to challenge that and say, actually, it wasn't a suitable alternative vacancy at all. You should have just made me redundant. That's the first place where it's applied, and the court will look at it and they'll go, what is the overlap in this Venn diagram here? That said, it can work the other way around. It has been used in case law the other way around as well. A tribunal can also assess whether a role that should have been offered was actually a suitable alternative vacancy. And so there are 2 slightly different ways of doing this, but again, it's still not, strictly speaking, an absolute. The test is, was it a suitable alternative vacancy by this objective measure and by this subjective measure? Don't rely on the idea that the tribunal is definitely going to say 70–80% of this was the same, therefore it was definitely a suitable alternative vacancy. That is not going to get you around that subjective test in what is the actual legal test for a suitable alternative vacancy anyway. Right, I've just got time for a few more questions, so I will start running through those quickly. If after the start of the consultation, employee would like to take voluntary redundancy, do we have to continue consulting with them? That's an interesting question. So in a collective, and I think collective is probably the important one here, in a collective consultation situation, I would say yes, and the simple reason for that is you can't contract out of that right. It's a very, very clear part of Section 188 of the Trade Union Labour Relations Consolidation Act. So if in a voluntary, let's just take a voluntary redundancy as an example, you're likely to do that by way of settlement anyway. So you cannot, under a settlement agreement, say, I waive my right to bring a claim under Section 188 for failure to collectively consult. So in that case, you might as well continue collectively consulting with them anyway. If they take a voluntary redundancy and have exited as part of the consultation process, then I think for the purposes of collective consultation, then you're consulting with reps. They are then passing on that information, so it almost becomes by the by in the sense that they're part of that process anyway. For the purposes of individual consultation, obviously there's lesser risk because there's not that sort of statutory claim that comes with the consultation process. They would be taken voluntary, and you'd be able to demonstrate in court later if they tried to pursue an unfair dismissal claim that the actual reason for their dismissal was a voluntary exit. It can't have been unfair because they chose to go under a voluntary redundancy process. Is there a difference between suitable alternative role and suitable role? For the sense of suitable alternative vacancy is sort of the legal test, so no, in that sense there isn't. But I think most people mean the same thing when they're talking about that. The only distinction I would probably draw is if you as the employer are trying to impose it, you want to use the official statutory language, which is suitable alternative vacancy. Suitable roles, what you could be saying in that situation is, we don't consider these to be suitable alternative vacancies for the purposes of the legal test, but these are roles that you may wish to consider applying for internally and for which you can apply in the same way as anybody else. You may want to draw that distinction and make it perfectly clear as part of the process that those are two different things if both arise. I probably wouldn't, I think if I was using the phrase suitable role, what I would probably be saying is these are roles which are available to you within the organisation, here's how you can apply. Suitable alternative vacancy, I'd make very clear that I mean that within the legal test. I appreciate we've just about hit time, so next session is going to be Wednesday the 8th of April. I think Nathan Andrews is going to join me to talk about probation periods and how they change under unfair dismissal rights from the start of next year, so that could be quite an entertaining one to be involved in. Again, for those of you who are local to the area, just a reminder, and we'll pretend I haven't missed the D out of reminder there, 18th of March, we are doing our in-person seminar at the Captain's Club. There's still some places available on that. It'll be in, what's that, 2 weeks' time. That will be an opportunity to sort of have a chat with us and with each other in person about the changes, how they're likely to affect you. I'll be talking about trade union rights, which I'm sure you'll be thrilled about, but we will cover everything else as well. So if anybody's local, hasn't signed up to that yet, please do have a look. I think some of the marketing content has already gone out. There is stuff available on LinkedIn. Other than that, I've seen there are a couple of questions. So what I'll do, I'll pause the recording in a moment, come to those questions, but I appreciate it's just about 11 o'clock. Thank you everybody for joining me. As always, look forward to seeing you next month. Look forward to seeing some of you in a couple of weeks' time. Have a good rest of your day, rest of your week. And as always, thank you for joining me.